दोस्तों इस क्लास में आपको डिक्टेशन दूंगा मैं 100 WPM पर 600 वर्ड्स की डिक्टेशन है, आपको डिक्टेशन में प्रोवाइड कर रहा हूं। बी रेडी फॉर इट।
The basic fact of the matter is not much in dispute. Respondent number 2 is a company registered and incorporated under the Companies Act 1956. The said company held and possessed the suit property situated in a district of West Bengal. It intended to sell the said property. Respondent numbers 1 and 2, having come to know of the said intention on the part of the company, entered into an agreement for sale thereof, wherefrom a sum of rupees 6,000 was paid to the company by way of advance. The balance amount was to be paid within a period of 14 months. As the title of the respondent number 2 in respect of the said property was not clear, the company instituted a suit against some persons who were claiming title there over on. The said suit was marked as title suit number 110. In the said suit, a compromise petition was filed, which having been accepted by the concerned court, a consent decree was passed on the basis thereof. Respondent number 1 thereafter issued several letters asking the company to execute and register a sale deed in his favor. The company, in response thereto, had all along been assuring the respondent number 1 that it would do so. By a letter, one of the directors of respondent number 2 assured respondent number 1 that no apprehension should be entertained by respondent number 1 that the contract between him and the company would not be honored. However, the company refused to execute and register a deed of sale in favor of respondent number 1 on the plea that the same became barred by limitation. A suit for specific performance of the said agreement for sale was filed in the court in a district of West Bengal, which was marked. It is not in dispute that not only the appellant herein had filed a caveat in the said suit, it purchased the said property during pendency thereof. Even in the deed of sale executed in favor of the appellant by the company, the factum of the said suit being pending in the court had specifically been mentioned. In the second appeal preferred by the appellant herein, it does not appear that any substantial question of law was framed by the High Court as was mandatorily required under section 100 of the Code of Civil Procedure. However, a learned single judge of the court dealt with all the contentions raised on behalf of the appellant and dismissed the suit. Mr. Santosh Mishra, learned counsel, appearing on behalf of the appellant in support of this appeal, submitted that the courts below committed a manifest error in arriving at the finding that the suit was not barred by limitation, purported to be relying on or on the basis of the first part of Article 57 of the Limitation Act, whereas in this case the second part thereof could be attracted. It was urged that the respondent number 1, in terms of the agreement for sale, was required to pay the balance sum of rupees 8,000 within 14 months therefrom. But even assuming that the deed of sale was to be executed and registered on perfection of title, the suit filed by the company against third parties having been decreed, the period of limitation in terms of Article 54 of the Limitation Act should have been reckoned from the said date. It was further urged that in the event the terms and conditions contained in the said agreement were found to be uncertain, the same would be void in terms of Section 29 of the Indian Contract Act. दोस्तों इसी के साथ ही डिक्टेशन फिनिश होती है और उम्मीद है आप लोगों ने इसे बहुत अच्छे से लिखा होगा। प्रैक्टिस करते रहिए। आज ही एक मैंने मैटर आपको प्रोवाइड किया था एसएससी का प्रीवियस ईयर का, जिसमें कि आपने देखा होगा मिक्स मैटर था, लीगल भी थी उसमें और पार्लियामेंट्री डिबेट भी थी, दोनों को मिक्स करके दिया गया था। टर्म्स काफ़ी अच्छे थे उसमें और जितने आपको मैं मैटर्स प्रोवाइड कर रहा हूँ इसी में से आपको वो वहाँ पे वर्ड्स मिल जाएंगे, तो चिंता की कोई बात नहीं है। ठीक है दोस्तों, अच्छे से मेहनत कीजिए। आपसे मुलाकात करता हूँ अगली क्लास में अगली ट्रांसक्रिप्शन के साथ। तब तक के लिए बाय बाय, टेक केयर।